Ya viongozi walioteuliwa na Rais William Samoei Ruto tayari wamehojiwa, mmojawapo akiwa ni Mheshimiwa Wycliffe Musalia Mudavadi ambaye anatarajiwa kuchukua wadhifa wa waziri mkuu wa taifa la Kenya, na wa pili akiwa ni Mheshimiwa Justin Muturi ambaye anatarajiwa kuchukua wadhifa wa mwanasheria mkuu wa nchi. Na hebu tupate jinsi Mheshimiwa Justin Muturi anavyojiwa na wabunge pamoja na spika wa bunge la kitaifa la taifa la Kenya. Hii ni runinga uipendayo ya KDR.
Honorable Mishimboko MP Likoni, a member of this committee.
Nelson Arab Koech, MP Belgut.
Thank you, Chair. Caleb Amisi, MP Saboti.
Dido Raso, MP Saku.
Abdi Shurie, MP Balambala.
Mary Emase, MP Teso South.
Stephen Mule, MP Matungulu, a member of this committee.
David Gikaria, Nakuru Town is constituency.
Naisula Lesuda, MP Samburu West constituency.
But not least, Deputy Speaker.
Gladys Boss, member for Wasingishu County, Deputy Speaker of the National Assembly. Thank you.
I'll invite the clerk to introduce the support team to the committee.
Thank you, Mr. Speaker. My name is Sarah Kyoko, the acting clerk of the National Assembly, and with me is the Deputy Director, Legal Services, and other staff from the various directorates who are supporting this committee. Thank you.
The Honorable Justin Muturi, welcome to the committee. We are going to have a process where the committee will ask you questions. We expect cogent, clear answers. We have asked ourselves as a committee not to engage in parochial issues, but to ask questions pertinent to and relevant to the office to which you have been nominated. So far, we have done very well with the previous nominee. All questions are asked through the Speaker and the Chair, and answers are channeled the same way, so that we limit any altercations between the nominee and the members of the committee. Before we start, we'll give you 5 to 10 minutes to make an opening statement to the committee in a manner you feel necessary. If you don't wish to, you can exercise that option. We are going to limit ourselves to that time, 90 minutes. So the manner in which we ask and answer questions must be within the context of the time available. And we want to encourage you, as a former colleague, to feel free and answer questions freely without fear or favor. So I'll give you the up to 10 minutes opportunity to make any statement you wish to the committee.
Thank you, Mr. Chairman, for the opportunity to introduce myself to the members of this committee and to the country. The statement you've requested of me, I suppose, is one about my private life, about when and where I was born. Perhaps it would be necessary for the membership to know where it is that I was born and brought up. I was born and brought up in Embu, approximately 66 years ago, in a village called Kanyuambora. Attended some local primary school known by the same name, after which I joined Kangaroo School in Embu for my secondary school education from Form 1 to Form 6. From there, in 1978, I joined the University of Nairobi for a law degree, where I completed and graduated in 1981. Thereafter, joined the Kenya School of Law, while at the same time undertaking pupillage with the law firm of GBM Kariuki at one point, and Ramesh Sharma at another, for the 1 year that I was at the law school. Thereafter, I was appointed at a district magistrate, class 2, and posted to Bungoma Law Courts, where I served for approximately 4 years, serving in various courts within Bungoma district, as it then was, as well as serving in Busia Law Courts. Later, in 1986, I was transferred to Githunguri Law Courts at a position of resident magistrate. In Githunguri, I served for exactly 365 days, after which I was transferred to Thika Law Courts, where I served for about 3 years and 5 months. And while in Thika, I was dealing, just like the other courts, with both criminal and civil litigation, and also did administrative work, overseeing the courts within Thika sub-districts, including Kandara, Gatundu, and Yatta in Machakos. In the month of April 1990, I was then transferred to Machakos Law Courts, where again I served for approximately 3.5 years. And while at Machakos Law Courts, I oversaw the administration of the judiciary, both in the then Machakos district, and which governed the current day Makueni County, as well as Kitui County. Thereafter, specifically on the 27th of September 1993, I was transferred to Nairobi Law Courts, and in Nairobi Law Courts I served mainly in the criminal division. And it was at Nairobi Law Courts where I left the judiciary when the bag of politics beat me, and I joined politics. From then on, in my first attempt in 1997, I did not succeed, but due to some unfortunate situation that happened, our Member of Parliament then died, and there was a by-election in 1999. I vied again and won. I served from 1999 up to 2002. Again, there was a general election. I vied, defended the seats, and I won. Came back to Parliament between 2003 and 2007. During that time, I also served as the chairperson of the Public Investments Committee, and also as the opposition chief whip. In 2007, I lost the seat and briefly went into personal private matters, but actively engaging in the constitutional review process that was then that had begun in the year 2000, and continued until the time of promulgation of the new constitution on August 27th, 2010. Also at that time, I served as the chairperson of the Center for Multi-Party Democracy, which was intensely engaged in the process of constitutional review, and did a number of matters, including the decision to go and seek a Supreme Court interpretation on the realization of the two-thirds gender rule then in the Constitution, and the Supreme Court did give an advisory that suggested that the principle would be realized through progressive mechanisms that the states would undertake. In 2013, I vying for the position of Speaker of the National Assembly, and the members graciously elected me on the 28th of March 2013, and continuing to serve both as Speaker and as is provided for in Article 127 of the Constitution as the Chairman or Chairperson of the Parliamentary Service Commission. We continued, and in 2017, after the general election, I again vied for the position of Speaker, and again the members graciously elected me to continue as Speaker on the 31st of August 2017, a position that I held until the first sitting of the 13th Parliament on the 8th of September, when I relinquished that position, and the position was, I believe, appropriately given by the members through election to yourself, Mr. Chairman. Thank you very much.
The Honorable Muturi, have you ever been adversely associated with practices that depict bias, favoritism, or nepotism in the discharge of your public duties?
No, Mr. Chairman.
Would you tell the committee your financial net worth?
Mr. Chairman, I've been a very modest public servant, and my net worth is currently estimated at just about 700 million.
What are your current and anticipated sources of income?
Currently, from my activities as a farmer and through consultancies that I do from time to time, do get occasional rewards. Otherwise, I am now a pensioner, a retired speaker, and expect that I should be governed, whatever I get from the public coffers should be governed by the Deputy President and Designated State Officers Act of 2015.
Thank you. We will now open the conversation, and the first to go will be the Deputy Speaker.
Honorable J.B. Muturi, as the Attorney General, you're going to be the principal legal advisor of the government. As you know from the past, the Attorney General or the government has lost very many major cases, one of them being the World Duty-Free case, the Kotek mining case, among others. So, and including many other cases against the government, including the President. How will you ensure that you deliver judicial wins for the government, or also ensuring that the government is not in an awkward situation of having flaunted the law and ending up in court? Thank you.
And we want to carry on as we take 4 at a time, then you answer them and we take another round. Kimani Chungwa.
Thank you, Honorable Speaker. And I'll just carry on from where the Deputy Speaker began from. As the Chief Legal Advisor to Government, Honorable Muturi. You know, under the previous regime, there has what was seemingly an abuse of the justice system for political reasons. I don't know what you intend to do now as government's chief legal advisor to ensure that the criminal justice system is not used by government, the government that you'll be serving in, for political ends. Two, in relation to what the Honorable Shalai has asked you, it's indeed true that government has lost a number of cases in court, and tied to that is a question of pending bills. Close to ₦1 trillion of adverse court judgments against government. What will be your immediate dues in terms of probably being able to renegotiate or negotiate with other litigants against government to help government to bring down this huge cost of pending bills in terms of court judgments?
Thank you. Wandai, the Honorable.
Yes, thank you, Honorable Chairman. The Honorable Muturi, I've got two quick questions. One, it is a matter of public notoriety that while serving in Nairobi station, you were once charged with a criminal offense, even though we know you were eventually acquitted. Perhaps what would interest us as a committee is, firstly, the prosecution did appeal the acquittal. We are not too sure what became of the appeal, if you could perhaps enlighten us. But secondly, could you also let us understand whether you went through the Ringera vetting of 2 or 3, and if you did so, why were you not reinstated to the judiciary? 2, you know, the progressive forces have over the years fought very, very consistently towards widening the democratic space. And this struggle has cost people a lot of things, including lives. As if this committee or the House eventually confirms you to this position, that you've been nominated, you will be the principal advisor to the government. And some of the areas or the issues you'll be advising the government on include matters of human rights, democracy, and so on and so forth. I have noted that you've been adversely mentioned in a book which I've just finished reading, that is Stronger Than Faith, My Journey in the Quest for Justice in Repressive Kenya, by one Udwor Ongwen. In this book, it's alleged that you betrayed the cause of the struggle for positive change within the university by, among others, university students in the early 80s. And as you know, political socialization it becomes more effective at the formative stages in life, especially at the university stage when you are a student. Could it be that you still hold those beliefs that could have informed your taking of contrary position to the popular position then by the university students? Which views could actually impact on your role as a chief advisor, legal advisor to the government, if you are confirmed? Thank you.
Robert Mbui.
Yeah, thank you, Speaker. I would like to ask the nominee, having been Speaker and now being proposed for the position of Chief Advisor, Legal Advisor to the government, do you believe that a Member of Parliament elected in a party or a coalition should be able to defect from that position without seeking the mandate of the public that voted them in? Is the member's political rights maybe superior to the voter? And the second one is, what is your legal position on the charges that have been dropped against nominees to the CS position this time round by the DPP, and those also that have been proposed to other executive offices? Thank you.
Honorable Muturi, you can answer those questions in succession, then we'll take another round.
Very well. Thank you, Mr. Chairman. Mr. Chairman, I must say that I wasn't quite clear about the question that the Honorable Deputy Speaker asked, because it touched on the case touching on duty.
She said the government has lost very high-profile cases through a perception of inadequate legal services from the Attorney General. Are you going to carry on with the inadequacy, or what are you going to do?
Thank you very much, Mr. Chairman. I think that's a very important question, in that my personal view is that it is not a right of government to always win cases, but government will win or lose cases depending on how much legal advice the particular entity within which the dispute is located. If it is, say, for instance, the Ministry of Trade or Ministry of Finance, it is important that all those departments, first and foremost, before committing government to anything, must seek legal advice. Of course, once the advice is sought, it may or may not be acted on. But of course, with the attendant risk, when they don't act on that, on those opinions, that they could easily find themselves on the receiving end. And in a number of cases, in fact, in the majority of cases, government has found itself on the receiving end because the Office of the Attorney General is brought in many of those cases at the tail end. It is not involved at the time when the government was being contracted into some particular activity. And therefore, my personal view about this is, if we have a robust, integrated legal management system, which will sift through all government departments, just like we have IFMIS, it helps the principal legal advisor to government to know at every stage, at the earliest stage, what government is about to, what kind of arrangements or engagements the government is about to enter into, and advise appropriately. And therefore, I myself, in a proactive way, propose that I would introduce such a system. But of course, all that will only happen when there is sufficient funding to the Office of the Attorney General. And this, of course, would involve not just the National Treasury, but also the National Assembly, in ensuring that the office is properly resourced. But I also want to agree with the Honorable Deputy Speaker that indeed government has lost in cases where, if properly advised and been sought ab initio, that would not have happened. And I think tying to that is the issue raised by the Honorable Ichong'wa, the Majority Leader, about the abuse of the justice system. But mainly the issue of those lost cases. The lost cases, I think I would myself want to deal with it as a matter that is now over and will not be resuscitating. But it is important that we appreciate that government, just like ordinary citizens, appear before courts as litigants, and should expect that in an adversarial system such as ours, they could either win or lose. But at all times, government should first receive the best available legal advice, especially before contracting. Some of the cases, some of the other smaller cases that government has actually lost has been, in my view, out of negligence, because many of them are either not adequately defended and some not at all defended, and we find judgments being entered against government on account of either inadequate personnel or inadequate preparation by those charged with defending government positions in court. With regard to the question of abuse of the justice system,
yes, so the Honorable
maybe Honorable JB did not get my question. Maybe I could paraphrase it. My question was, and truly what you are saying is true, that some of the cases could have been lost by government because of negligence by officers in the state law office in not defending government properly. And therefore government has been surcharged or rather as judgments against it that amount to amounts some that are obscene for some cases. And cumulatively, if you look at all those judgments, I think they're moving close to 1 trillion shillings. And my question was specific, as AG now, knowing, as you say here, there might have been negligence by state law officers in defending government, what do you intend to do? Because we cannot subject the Kenyan people, Kenyan taxpayers, to pay those huge bills out of the negligence of officers in the state law office. So what do you intend to do if you are approved as the AG to make sure that you save on taxpayers' money, not even government money, on those judgments? That was a specific question. I wanted to hear what your intention.
No, on those judgments, if they have been finalized, there is nothing that the Attorney General will do, save to advise that the government settles those that have been finalized. Those that have not been concluded, of course, the Attorney General will take up the matter and apply the best foot forward in ensuring that government gets the very best out of them. But I'm saying moving forward, not the historical ones, going forward, I think there is need for all government ministries and departments to ensure that they involve the Office of the Attorney General, especially before entering into commercial contracts, because some of them are entered into. The brief that I have is that some of them come to the Office of the Attorney General, and the Attorney General's office looks through them and begins asking, why did you enter into this kind of arrangement? It is obvious that you are going to find yourselves in a mess. Some of them, like the construction case, contracts, you find that maybe some functionary in a ministry may not have been happy about somebody who was awarded the contract, and feel because they come, pushing their way forward and say, terminate this. Obviously, with the consequences that the party that is aggrieved to go to court, and chances are very high in those kind of situations that government will lose. So that's why I'm saying, going forward, it is important that we have a policy understanding that the constitutional mandate of the Office of the Attorney General to be the principal legal advisor is taken seriously by all government ministries and departments, so that we are able to avoid some of these losses that impact on even our economic performance. Of course, with regard to the abuse of the criminal justice system, it's only fair that everybody appreciates that even though the Attorney General coordinates some of the activities within the criminal justice system, criminal prosecutions are undertaken by the DPP. And as you know, in the performance of his functions under Article 157, he is not under the direction or control of any person or authority. But I think working collaboratively, it is fair that in a democratic country, we need to appreciate that people may hold differing opinions from even you as a member of parliament or even you, the Attorney General, but that does not in itself entitle the party that feels that they have weight and power to use the criminal justice system. It is just a matter of discussions and agreeing with people that going forward as a country, let us embrace the divergence of opinions, and it's not a crime. On the pending bills, Honorable Ishongwa, the report I have is that a task force had been set up, which came up with a report indicating that the pending legal bills arising out of court judgments currently stand at about 151 billion. Of course, it is a strain on the exchequer, but unfortunately, ministries do not budget or they don't provide for these debts. Yet there are debts which must be settled. Some of them, the smaller ones, which is really the more pitiful situation. You may find that some judgments have been entered against government. Maybe some government driver went and knocked somebody, some citizen somewhere. They went to court, got judgment, and for well over a decade, they have not benefited from those judgments. It's really an unfortunate situation that, in my opinion, should not happen. But I would be advising that they make provision. But of course, the Honorable Ishongwa, having been the chair of the Budget and Appropriations Committee, is aware that some of these matters, when they appear before the committee, they don't look very urgent. But I think I would be appealing to Parliament, particularly the National Assembly, to look into some of these matters favorably. The Honorable Opio Wandai, the minority leader and member for Ugunja, raised the issue of the criminal case that was filed against me. I just wish to inform the committee that, through you, Mr. Chairman, that that case was dismissed at no case to answer. In fact, in the judgment, it was described as one built on quicksand. The Attorney General's office, which was, and it's unfortunate, I didn't want to go to this, but I must say it to clear there. The Attorney General's office, which at that time was responsible also for criminal prosecutions, appealed. And I was not surprised that they were appealing because the case actually originated from them. They knew what it is that were pursuing against me. But again, the appeal was dismissed by the late Honorable Justice Oguk. So nothing really came of it. Vetting by Justice Rengera, it was something which was famously known as radical surgery or surgery by radicals. Unfortunately, when that surgery was happening, I was a happy member for Siakago constituency in 2003. And you needed to come to Bunge to deal with us differently. So I did not have to be taken to him. The Honorable Opio Wandai, Mr. Chairman, also raised a very pertinent issue about the issues of human rights and democracy. And as you know, if you look at the functions of the Attorney General, one of it is to advise the government on the issue of human rights. In fact, the Department of Justice within the Attorney General's office specifically deals with that issue of advising government on matters of human rights and democracy. And therefore, you can expect that there will be robust engagement with the various arms and various actors. Remember, one of the reports that the President has to deliver to Parliament, and Article 132 is one showing what steps the government is taking towards implementing the many values contained in Article 10, which include, among others, human rights and the enforcement and implementation of international treaties. And therefore, when that happens, the president usually is advised from the Attorney General's Office, Department of Justice, on the steps that have been taken. But to go further, it's also to inform the committee that if you look at Article 59 on the establishment of the Kenya National Commission on Human Rights, one of the issues that commission is charged with is the enforcement of issues to do with human rights. And though it's an independent commission, that commission works in close cooperation with the Office of the Attorney General with regard to matters to do with human rights and democracy. There's a question about Mr. Oduor Ongwen about a position I took in regard to some demonstration that was happening in the university. I can inform the committee that that was approximately 41 years ago. I suspect not very many of us were born, but it's just a matter of expressing a divergent opinion. There had been no formal body at the university since the proscribing of the Nairobi University Students' Union, NUSO. And what used to be there was a body that was loosely called SRC, the Students' Representative Council. And as the chairman then of the Kenya Law Student Society, I was co-opted into it. In that body, we had debates, very robust debates, and there was some people took the position that we needed to go to demonstrate. Some of us who were just exiting university were of the contrary view that we didn't think we had the luxury while we are preparing for our exams to join the rest in the streets. And therefore, I'm surprised that Mr. Ongwen thinks that was betrayal of democratic or anything progressive. I don't know what could have been described as progressive then. I suspect he was not even in the university at that time. He must have had rumors about what happened. But, you know, this is the beauty of our country in a democracy is to allow people to express themselves whichever way they choose. But as the Attorney General, I would defend his right to continue saying that, as much as I continue also saying that it was not progressive. So it's here not, Mr. Chairman, is not something that I think would reflect in any way on my suitability in the office of the Attorney General. Mr. Chairman, the last question was by the member for Kathiani, the Deputy Minority Leader, the Honorable Robert Bui, on the defection of MPs. I think, Mr. Chairman, when we talk about when you go to Articles 36 and 38 of the Constitution, it becomes quite clear that every person, every adult person is entitled to those rights. And I think we need to appreciate that our Bill of Rights is one of the most progressive and robust in the world. And it is no wonder that given the history, the political history of this country, before the promulgation of the current constitution, we Kenyans felt that there was need to place almost everything without exception in the Bill of Rights. It's actually the biggest, it's actually the longest chapter with a total of 41 articles. So everybody has a right to form and be in a political formation. When that person decides that they no longer want to be in a particular formation, I cannot myself be persuaded to say that they cannot. Of course, the attendant issue that goes with that one is the party, the political party, would then be at liberty using its internal processes to discipline any member that it feels has in any way injured its position, not just in Parliament, but anywhere. Remember, when we did the Political Parties Act, Mr. Chairman, we went to great lengths to provide even for disciplinary mechanisms that a political party should follow in dealing with its members whom it may deem errant. And of course, going on to even provide in Article 103 what should happen in the event that the member is a member of Parliament. But I'm willing to engage on the technicalities that are there, but for now, suffice to say that I think a member is at liberty to choose to make decisions as they find appropriate. And if the party to which they belong feels aggrieved, then the party can proceed to take necessary disciplinary action. The Honorable Robert Bui, Mr. Chairman, finally asked a question of my view on the dropped charges. I think I will express myself in general terms because, again, that is the domain of the DPP, even though as a national, the AG chairs the National Steering Committee on Anti-Corruption, which brings together many bodies, including the DPP. But again, since the reasons that informed the DPP were not made public, it would be, I think, premature to start ascribing particular positions on those dropped charges. Safe to say, if you look at Article 157, and I'm sorry, Mr. Chairman, because this again goes to the powers of the DPP. The DPP is empowered in Article 157, clauses 6 and 7, to commence, take over, and drop any criminal charges, except any that are not before a court martial. Yeah, and therefore, the DPP is best placed to respond to this because the reasons are only known to him.
Yes, the Honorable Junet.
Chair, I didn't want to interrupt the nominee, but also the Constitution says that, I wanted to remind, because we're in a public forum, that the DPP must give reasons for withdrawal to the court, not just to drop them like that. 88. 157.8.
In fact, it doesn't say that. It says that the DPP will not withdraw except with the leave of the court.
Yeah.
I'm quite, you know my position with regard to the Constitution. With regard to the Constitution, so we wait for the courts.
No, Mr. Speaker. Chair, it says, let me read from the Constitution, the director of the public prosecution may not discontinue a prosecution without the permission of the court.
It's the same thing.
Yeah.
It's the same thing.
Exactly, Mr. Chairman. The leave of the court,
In law,
that's the
permission
permission.
and leave are used
Mr. Chairman, it's
yes.
Mr. Chairman, I think we are saying the same thing.
Yes, it is the same thing.
With the honourable member.
Yeah.
But again, because we don't know whether the courts have given permission. So again, it may be incoherent for us to start saying this and this has happened, because the courts before whom the DPP is making the application will ask for the reasons. And maybe if the courts are not satisfied, the court is not satisfied, it might refuse. But remember again, that same, we go slightly above there in clause 7, if the withdrawal comes after the DPP has closed his case, it results in the acquittal of the accused person. And that would have, some bearing on, then of course, and these are some of the things that I was saying earlier on. Remember, this is, even you, honorable member, may be taken to court. And if the reasons for which you have been taken there are not justifiable, you also have a right, after that acquittal, to even sue the government. So again, the matter will find itself with the Attorney General, because now that will be civil. And that's why I was saying, we must work, in a collaborative way with all these agencies and ministries. Thank you, Mr. Chairman.
Can see that the interest is immense. So one question each member and a succinct answer from the nominee. Mishimbogo, Gikaria, Emase, Ferdinand. Second round, I'll come to you.
Thank you, Chair. Yeah,
Yeah.
Thank you, Chair. In the perspective of the litigation against the government, which attract huge monetary claims, and this is being made from the ministry, from the department, and maybe government agencies. The reason has been sometimes we fail to effectively negotiate on financing agreements. And I'm citing on one project, the SGR projects. Last Parliament, the reports from the PAC stated that certain ministry ignored some advice from the Attorney General on the issue of the SGR. And today there is a lot of conflict, there are a lot of challenges in terms of how are we going to finance the agreement between Kenya and the Exim Bank of China. So my question is, how are you going to do it differently in case of a scenario where you have given a certain advice, but then it is rejected or rather ignored by a certain ministry, whether a department or an agency of the government? Because we need to do things differently to ensure that there is value of the public funds in terms of public investment projects. Thank you, Mr. Speaker.
Karia.
Thank you, Chair.
Honorable.
Pengine niseme pongezi kwa ndugu yangu Bwana Muturi, na niulize katika nchi yetu ya Kenya, Wakenya wengi hawapati nafasi. Actually watu wengi wanafungwa kwa sababu ya kukosa usaidizi wa mawakili, na wengi hawana hela za kuweza kulipia gharama ya mawakili ama mambo mengine. Na Wakenya sana sana huwa kwa sababu hawana nafasi hiyo ya kuweza kushika wakili aweze kuwatetea katika kesi zao, wanajipata wanafungwa, na wengine pengine hata wana hatia, ama wengine wanapatiwa mawaidha mabaya kwenda kukubali kesi ambayo inamweka ndani. Na nasema hivi kwa sababu najua kuna kijana amefungwa miaka 5 kwa kwenda kuvua samaki tu pale Lake Nakuru. Sababu aliambiwa kubali na amefungwa, sasa hayuko. Kama angepata legal advice, ofisi yako iko na hiyo nafasi ya kuweza kupeana. Pengine Wakenya wataweza kujua kwa njia gani wale wamefungwa that kuna usaidizi kutoka kwa ofisi yako, ndio wale mahasla ambao wanashikwa kwa sababu ya sheria ambazo hawajui wanaweza kupata usaidizi kutoka kwa ofisi yako. Asante.
Thank you, Mr. Speaker. Thank you, Mr. Speaker. I want to draw my question from the nominees' resume. I noticed that you've been a member of the African Parliamentarians Against Corruption. You're also a member of the Global Organization of Parliamentarians Against Corruption. Mr. Speaker, noting that corruption is still a major menace and an impediment to the realization of our development agenda or targets as a country. I want the nominee to tell us what is going to do to strengthen the legal frameworks in liaison with other institutions, because we witness that there's a lot of delays in prosecution, a lot of delays in investigation, blame games between the EACC and the Office of the DPP. So what are you planning to do in order to address these issues to make sure that there is justice? Justice is not delayed, and Kenyans get justice, and corruption cases are addressed efficiently and effectively. Thank you.
Muturi.
Sorry, Mr. Chairman, I thought you had indicated the Honorable Ferdinand Wanyonyi.
Sorry, Ferdinand. He showed no enthusiasm in pursuing the question.
I didn't know what? You slept on your right. I said on my right. Okay. Chair, I want to ask the AG, and I think you are up to the task. From the way you are talking, you are up to the task. Yeah? But my question is that in your role as an AG, you will also serve as a member of the Judicial Service Commission. That's your work. Complaints have been made, and I think I'm one of them. I don't want to specify which complaint, but we've made complaints about these officers, judicial officers, taking their work very casually, and it takes time for them to come back to you as a complainant that your case is coming up or something like that. What do you want to do? How will you help the public in that case? Thank you.
Yes, Honorable.
Thank you, Mr. Chairman. Let me begin with the one by the Honorable Wanyonyi. I think all complaints raised against judicial officers with the Judicial Service Commission have to be addressed promptly. But I think there may be some need for public awareness, because I think we still have a large segment of our society that is not really quite aware of the functions of the judiciary. It may not be necessarily the work of the judicial officer before whom a case is filed to inform the public about when the case is coming, except if the matter is being heard and there's an adjournment, then if a date is taken, it's the work of the judicial officer to indicate, and that is normally done publicly. But I think given the situation of COVID and how the judiciary has adjusted, we may perhaps have to think of introducing, Mr. Chairman, other methods, not just the internet, but other methods through which people in whatever part of the country are able to access the court lists in courts to know when their matters will be coming up either for hearing or for mention. And some of these terminologies, sometimes my view is that at the Judicial Service Commission, as a policy level, we should be able to advise that let's explain to the public when you say a mention, because I've seen a situation whereby a case is listened for mention and a litigant is ferrying witnesses because they don't know whether is mentioned hearing, is the case going to be tried, things like those. I think it calls for more robust awareness creation by the judiciary itself. But let's also appreciate this system which we introduced of court users association, as when it is fully implemented, it's going to help a great deal in enlightening members of the public and litigants in particular about the court processes. Where a person is seen to be just lazy, then appropriate disciplinary action should be taken by the JSC. The member for Teso South, Mr. Chairman, the Honorable Mary Amase, raised the issue of matters to do with corruption. Whereas I take it that in most cases we see these matters only with respect to criminal prosecutions. Indeed, I want to agree with you, some of these corrupt matters, cases are within the civil section of the judiciary. Because some of those contracts, sometimes you find that they are tainted with aspects of corruption. And for me, I think public information is the way to go. And I'm happy, Mr. Chairman, that indeed the President is leading from the front and has put everybody on notice, particularly public servants, that if you have a long hand, you are unlikely to survive in his government. So public information and public awareness is important. And as you know, these bodies, both APNAC and GOPAC, really, they act as, bodies that create awareness, but within the parliamentary setting. Within African Parliamentarians Network Against Corruption, and at the global level, again, is a global organization of parliamentarians against corruption, so that they act as bodies that help to create awareness within the setting of parliaments, both in the continent and the world over. The Honorable Gekaria raised the issue of hustlers who don't understand about who are not aware that there is legal aid. And legal aid is one of the functions of the Office of the Attorney General, I must say. And my view is that that is an aspect that the Office of the Attorney General should take seriously, given that the majority of our people hardly know or understand some of those processes, judicial processes. Indeed, it is against the Constitution. It's against the Constitution in the Bill of Rights, Mr. Chairman, to mislead a person who's been arrested to make a confession, because that's amounts to a confession. And I think the Office of the Attorney General needs to be much more proactive by providing information. And there is I would be suggesting that in terms of Article 6, Clause 3, the Attorney General's office as a state organ should endeavor to devolve its services to the lowest level possible, and in doing so, actively engage the public. And there's nothing wrong even going on television. An Attorney General should not feel that they occupy any special position, should go to television and explain to the public some of the things that, that your office is doing. But on a more positive note, Mr. Chairman, I'm happy that His Excellency the President has indicated, and I hope honorable members will take this positively, that cabinet secretaries, including the Attorney General, will now get an opportunity to appear before the floor of the House to explain some of these functions where there is need and whenever Parliament desires to get that kind of information. And I myself, as you know, I have been the greatest proponent of that process where, government functions and policies should be explained to the people's representatives on the plenary of the House, because that way you end up creating greater awareness than you could possibly even do through television appearances. So, Honorable Chairman, in response to the Honorable Gekaria's question, that's what I would say. Again, more and more robust engagement with the public. Finally, Honorable Chairman,
The issue raised by the Honorable Mishiboko is a very serious one because I know for the last almost 8 years, there's a matter that has, exercised the minds of, the legislature particularly, and various committees of the House. But I think if we implemented an integrated management system, legal management system of the magnitude of IFMIS, it means that anything happening in the smallest unit of government will have a way of getting to the Attorney General up in issue before action is taken to avoid, and if indeed Parliament were to help the Attorney General's office to achieve this, it would be an extremely important achievement because, one, we will be in a way able to tame some of those underhand dealings that happen in ministries, and only later to end up in a court, government being sued, and in situations like the one the Honorable Mishi raised, threats being made by outside bodies. Thank you, Mr. Chairman.
Owen Bayer. I can see some soliciting through facial. Rahab Mukami. I'll give Naisula and Dawood. Wait for the next round. If you can also be as precise and concise as the last batch of 4, we'll make very good progress. Owen.
Thank you, Honorable Speaker. My question to the Speaker Emeritus, who is the nominee for the Attorney General Office, is that during your tenure as Speaker, we lost several laws at the judiciary. When they were taken to court, we lost them. Seemingly, these laws passed through the Attorney General's office from the Ministerial Cabinet and the journey into Parliament. Under your stewardship, we lost several of those cases, and they were termed unconstitutional. But we also used to call you in Parliament as the working dictionary of the Constitution, because you have every, but we lost several of them on the aspect of constitutionalism. How will this be cured so that Parliament is not embarrassed again in court? Secondly, if the chairman would allow me, there has always been this battle of which is the upper house, and your several pronouncements in Parliament indicated that the National Assembly is the upper house. Now that you are going to be vetted and become Attorney General, how will you cure the supremacy battles between the two chambers of the House? I thank you.
So what's the next?
Congratulations, our former Speaker. What I want to ask you, what strategies will you put in place to promote administration of justice, bearing in mind that majority of Kenyans cannot afford legal fees in the court?
Thank you. Next, Naisula.
Thank you, Chairman. To the nominee, former Chief Justice David Maraga is quoted having said that the government cannot demand of its citizens the obedience of the law if those in authority were disobeying court orders with abandon. As a departure from past practice, the Kenya Kwanza administration pledged to obey all court orders. The other day, the Public Service Commission advertised for the Chief Administrative Secretary jobs. LSK is already in possession of orders, but the PAC in its latest statement was categorical that the recruitment process will continue uninterrupted. There are indications that the current administration is keen to retain the positions so pre-election agreements can be honored through appointments. As the AG, what is your position on this matter, and especially on ensuring the rule of law is followed throughout and not only when it suits the government or the executive?
Thank you. Thank you, Chair. Chair, I'd like to ask, first of all, congratulate our Mr. Speaker on being nominee for AG. I would want to know, how are you going, one of the functions of the AG's office is constitutional implementation, legislative drafting, and the other one is legal aid, which you have already talked about. But I think we need still more what you have said to Honorable Gikaria, because a lot of citizens cannot afford legal aid. And if you can fashion something like the Citizens Advisory Bureau, which is in the UK, something on similar lines, which would be probably be based in Huduma centers or something like that. But my question to you, nominee AG, is the Constitution has been there, the new Constitution 2010. We still call it the new Constitution. There are many laws which have not been implemented to date, have not been enacted, or they are not being followed up. So you as the AG, what will you do to put into effect all the laws which are in the 2010? Because I remember I was in the CIOC and we left many laws which have not to date been implemented. So as the AG, how do you take that? And about the pro bono services, because this is a hustler's government. So we need pro bono services for the hustlers because they cannot afford it. The rich can afford their lawyers, and not just for criminal cases, even civil cases, because there are land cases which are there. People are being moved out of their lands and they cannot afford it. And the rich get away with those atrocities. So how are you going to assist them? Thank you.
Attorney General nominee.
Thank you, Mr. Chairman. And starting from the question raised by the Honorable Wandbaya, first of all, on the issue of upper or lower house, I want to say that my experience is that this is it's neither here nor there. It's a matter that you find in very many jurisdictions where there are two houses. And as you know, even when you're campaigning, there's always one person claiming to be better than the other. But the electorate will always make their decision. The roles of each house, in our case, are clearly provided for, so that the issue of which is upper or which is lower shouldn't even arise. It should be who is performing what role. You look, because both houses are parliament in terms of Article 93. The legislative process is clearly provided for in Article 94. Then the roles, specific roles of each house provided for in Articles 95 and 96, so that there should be no conflicts, and for me, the issue that was raised about lower or upper house, I think should not even preoccupy us. If anything, I think it is diversionary. And sometimes we should leave it for people to enjoy. It happens actually even in other jurisdictions. If you go to London, you find about the House of Lords. The popular refrain there is that it is the largest regular gathering of retirees. So these things are always there. These are jokes. But when you check how the two houses operate and relate to one another, there is a lot of difference. So because everybody knows their specific area of operation. With regard to laws, let me say that there have been a few laws that have been part of them annulled. But really, the house's function is to make a law. It is the function of the judiciary to interpret. And I think we should not even feel unhappy, because remember, you have played your part. You let the judiciary go and play theirs to do interpretation. The area where there was some little bit of contention was with regard to the application of the provisions of Article 110.3, with regard to, the specific provision is actually quite testing, and I think it's a matter that since it, and I don't want to go into a lot of details because, as you know, there's a matter pending before the Supreme Court, and maybe it would be a bit unfair for me to go into a lot of details. But you just need to look at the specific wording of Article 110, Clause 3, and see it creates there's some gray areas, because it says before any House of Parliament considers any bill, the two speakers of the National Assembly and the Senate shall resolve any question as to whether, one, it's a bill concerning counties, two, if it is, whether it's an ordinary bill or a special bill. So it's a matter that there's been some contention there, because when is a bill considered? Is it when it is published? Is it when it is read for the first time? Or is it when it is coming for second reading during debate? So I think that's a matter that I think it's only fair that we leave that to the judiciary to advise all of us, even though we also have a duty and obligation to interpret the Constitution, but the final arbiter must at all times remain the judiciary. The Honorable Mukami, yes, I agree with you that court fees are quite high, but remember now we are in a free market economy. And I sympathize with the situation whereby many of our people cannot afford the legal fees charged by our lawyers. But also, on the other hand, it is an truism that which we cannot escape, that whatever it is that the Attorney General, the Attorney General's office can be given to address this issue, it's only so much. And again, it comes from the National Assembly to decide how much you would want to give to the office of the Attorney General to pay for this. It's a very, very difficult situation, and particularly in civil matters, it will be so difficult to know, because people will differ about this. Maybe somebody wants to divorce, and they're saying that they are not able to afford the fees to divorce their wives or their husbands. Now, how is the Attorney General going to come to say, to step in to come and pay fees for them? It's one of those things that it's like the chicken and egg situation. One, it's an issue that we sympathize with, that fees are quite high, but inappropriate public interest litigation, as you all know, courts, there are no fees charged. The Honorable Lesunda, Mr. Chairman, has asked a very interesting question about obedience of court orders. What I know is that there is a pending matter in the Court of Appeal on this issue of that same matter that the Public Service Commission is undertaking. There was obtained, there was a judgment by the High Court in that original matter, but there was an appeal filed, and in that appeal there was some conservatory orders that were issued, which the current administration felt should not be the situation, decided to follow the Constitution, because, you know, Article 132, Clause 4 permits the President to establish any office in the public service and make appointments thereto on the recommendations of the Public Service Commission. The issue which was raised in the earlier case was that there had not been public participation before the establishment of the office of Chief Administrative Secretary. So the current administration felt that they wanted the PSC to involve the public and advise the President. I'm not able at this point to know whether the advice has come from the PSC to the President. But, you know, so I can only comment to the extent that I am aware that, and I think almost everybody here knows that the Public Service Commission advertised for, to the public, for people to send views on the suitability or otherwise of the creation of the office of Chief Administrative Secretary. I believe there have been quite a number of views, representations made to the PSC, the results of which are not, they are not with me. Since I'm merely a nominee, and I'm not supposed to know what it is that happened. And in any event, they were supposed to advise, as per the Constitution, the President. They are not, even in doing that, required. If you look at the specific provision, they are not even required to engage or involve the Attorney General in that matter, because it's up to them, once they have received views, to present to the President their recommendations. Finally, but therefore, let me just say this. I intend to advise the entire government that, the three arms of government, and indeed even the devolved units, yes, there is the principle of separation of powers, which is important in our constitutional architecture, but there is also need for each to respect the others. When Parliament makes a decision, the executive should respect that decision, and so the same should apply to judgments that have been given by courts. If there have not been any appeals, or even if there are appeals, they should be obeyed to the extent that an appeal has not invalidated the orders that may have been made. Finally, Mr. Chairman, there is the question raised by the Honorable Dawood, part of which is about on this issue of legal aid. See, legal aid must be understood to not just be limited to pro bono services. The Office of the Attorney General doesn't have the personnel, and I think will never have the personnel enough to give pro bono services to every citizen. The best that the office can do is to just give general information. And my position is, once we are able to roll out the services of the Office of the Attorney General to every of our counties, because currently we are only in 13, and that leaves quite some big part of the country without the services of the Attorney General. We can only do so much, because we are limited both to both space, resources, both the human and financial. In several cases, like I said earlier on, it becomes very, very difficult for the Office of the Attorney General to really give free representation to citizens, because the range of disputes in civil matters is so wide. The Office of the Attorney General cannot possibly contemplate what is likely. Somebody will be saying this from Garissa, another one from Migori will be suing another one, and it's not possible. And not all the cases are against government. Some of them are disputes between citizens, both human beings and juristic persons. So it's likely to be quite a challenge to the Office of the Attorney General. With regard to the cases, the number of laws that have not been implemented or passed, Mr. Chairman, the challenge goes back to Parliament, because if you look at, although I can say here authoritatively, if you look to the 5th schedule, all the laws that were supposed to have been enacted by the last two parliaments, in fact 3 parliaments, have all been enacted. If you go to the schedule in the fifth schedule of the Constitution, all of them, without exception, were passed by the last 3 parliaments. So there isn't any that one can say has not been passed. I'm also, I can also say authoritatively that there are several others which were not in the 5th schedule, which, through efforts of individual members, have also been enacted. I know that
they still, Parliament was supposed to enact legislation to give effect to Article 100. And I'm aware that the last Parliament, I think the National Assembly had already done their bit and referred the bill to the Senate. Well, this is a new Parliament. I think that can be, the matter can be reopened. But I think I would want to enlist the help of the National Assembly in particular in combing through the Constitution and seeing which other areas of our Constitution may require legislative interventions so that working together we can do it for the benefit of the people of Kenya. Thank you very much, Mr. Chairman.
Janet, Koech, Raso, Mule. You'll all have an opportunity, don't worry. At one question each.
Yeah, thank you. Thank you, Mr. Speaker. Chairman, Honorable Attorney General nominee. My question is, you have served as the Speaker of the National Assembly for the last 10 years, especially under the new Constitution. You're the first Speaker who came after the new Constitution was promulgated in 2010. So 2013 was the first Parliament to implement. And as you are aware, the biggest problem with following the law, the Constitution, is normally with the executive. And for that matter, they will want to interfere with other institutions and other arms of government, like judiciary and parliament. What is your experience as a Speaker for 10 years? Was there a lot of interference from the executive? And as now someone who's sitting at the Attorney General, what will you advise the government on how they should not interfere or not to deal with other arms of government? And also the issue of how do you intend to make sure the country is run by the rule of law and constitutionalism? That the executive is the one that normally has a problem with the law, as I've told you. So how will you make sure that they follow constitutionalism? An example, a point in case, as late as yesterday, is that the Constitution says, and I'm happy, that's what the new government wants to implement. They were making the police service to be very independent and making the Attorney General, the IG, have financial independence and those things. But yesterday, I came across an incident, Article 245. It says that the minister in charge of police can give police orders in terms of policy issues. But no any other person can give the police instructions on what to do. But the president gave them instructions yesterday to disband a unit of the DCI. Is that constitutionalism, Mr. Attorney General?
Congratulations, Mr. Speaker. Yeah, sorry about that. Congratulations, Mr. Speaker, on your appointment as the Attorney General. One is the courts ruled on the CDF, Constitutional Development Fund. Up to now, there has not been disbursement, even emergency. What is your interpretation on the ruling? And going forward, then, what will you, how will you guide the government? Thank you.
Thank you very much, Mr. Speaker. Honorable JB, congratulations on your nomination. If the House approves your nomination, you are likely to have worked in the three arms of government, maybe among the few. My first question is, what will haunt you is what you pronounce from the floor of the House, why the executive must respect the summons by Parliament. And you kept on saying severally. So that leads me to my question on the issue of extrajudicial killings and the disappearance of Kenyan citizens. This in itself is violation of human rights and the Constitution also. What are we likely to see under your watch as the state legal advisor? Thank you, Chair. Mule.
Thank you very much. I want to say congratulations to Honorable Muturi. We have worked closely together on the TB caucus for 10 years. Mine is on two fundamental issues which lies with the Office of the Attorney General. That is the international agreements and the cases which are likely to bear direction from your office as the Attorney General, whereby we look at the case whereby Kenya lost to ICC on the Mediterranean border with Somali. And I do intend to appeal or advise the government of the day on how best to resolve that dispute instead of going full throttle to claim the good stature. The second one is the issue of Migingo, which lies in that preview of the international borders of Kenya, whereby Migingo has gone silently, and we are not aware as Kenyans at the end. And on the agreements, as Attorney General, there are so many agreements which have been sent to the Attorney General. Some of them have not been effected, like the agreement for Qatar for building affordable housing, which has been lying there, and then it elapsed, and we lost almost 5 billion shillings as a country. And also the agreement between Kenya and Britain regarding the issue of Tuk in Laikipia, which really affects the interests of Kenyans and the interests of our international relationship with Britain. As the Attorney General, and if we approve you, how are you going to deal with these issues which are clearly within your office and advise the government the best way possible?
Yes, Honorable Muturi.
Thank you. Thank you very much, the Chairman. The Chairman, the Honorable Minority Whip, the Honorable Junaid Mohammed, raised the issue of interference by the executive and the issues of the rule of law and constitutionalism. But I think he directed himself, the intention was to ask the last question on the disbursement of the SSU, as I read it. I didn't know that there was such an outfit. But Mr. Chairman, every government is elected on the basis of some program and policy that it has to formulate when in office. And this government has clearly indicated that they want to get to be involved, particularly with Parliament, when dealing with issues of its policies. And for that reason that there is this request that Parliament allows Cabinet Secretaries to appear before the floor to respond. And I think this is, again, really just actualizing the provisions of Article 125. And being the people's representatives, I think Parliament should be kept informed of all decisions that the executive is coming up with. My view is that every arm of government should know what is required of it under the Constitution. The Office of the Attorney General seconds legal counsel to every ministry. And indeed, it is my position that I would want those legal counsel seconded to the various ministries to be the first point of call whenever the government is getting involved in any issues that have to do with the administration of the law and issues that touch on the constitutional requirements. But let me say, the president is the head of the executive. And it is quite in order for him to use, what has been said by his cabinet secretary maybe quietly, it is quite open to the president to say it publicly that that he has instructed for this to happen. Remember, indeed, he is the foremost spokesperson of the government and indeed of the country. And therefore, I don't see any interference, so to speak, with the functioning of police. And I think we all must allow that from time to time, communication will be made which explains what government is doing with regard to various activities that are taken by various agencies. Honorable Koech, Mr. Chairman, raised the issue of the CDF ruling that came on the 8th of August. Quite an interesting date for the ruling to have come, because I was reading it as I was driving to the village to go and vote the next day, and it was a bombshell. But I think consultations are ongoing. It is agreed by many people that that what CDF has been able to achieve in this country is phenomenal, and I think we can be able to work on around ways. Remember, there were some areas that the court took issue with. One, the area of shareable revenue, so that we can address that one as Parliament. Actually, Parliament can address that one by going through, look at what is provided for in Article 202, so that CDF does not become part of that mechanism of sharing national revenue, so that what remains with the national government becomes the place where CDF should be hyped off from. So I think if we can consult on that area, I think we can make the necessary adjustments. And it's unfortunate that as a result, no disbursements have been made so far. I think it's really an unfortunate situation. The other area which we need to address, and I think this is within your powers as members of Parliament in the National Assembly, is what the courts went to great lengths to explain about service delivery. And I'm sure, Mr. Chairman, looking through these members, these are fairly clever members. We can deal with that. I think it's something that we can work on. And I'll be available. Because I truly feel that CDF should continue. On the issue of extrajudicial killings, Mr. Chairman, I think I would want to associate myself with the outrage that His Excellency the President, expressed yesterday. I think, being a country governed by the rule of law, we should never have a situation whereby, this is happening in our country. And from me, you can expect that we will be, advising the relevant agencies to be on the lookout that even this is a way of actually burdening the taxpayer, because those who lose their loved ones through these processes obviously end up suing the government. The government has no money of its own. That money comes from the taxpayer. And I think we also need to revisit, and I want to make a plea to Parliament, because I know you also make a lot of recommendations, that we need to bring back this issue of surcharge, that individuals must be surcharged when they do things which are outside of their official responsibilities or duties that they are given to. The Honorable Mule, on the issue of international agreements, and I'm doing it very quickly, I will need to study the issue of the maritime dispute with Somalia, as well as the report that came from the committee that dealt with the issue of Migingo. I believe these countries being our neighbors is something that we can be able to amicably resolve. There's no need of going to war over such. And I think because I know there are some reports. And on this issue of the dispute with Somalia, I know there is a matter, there's a committee that is handling it, and I'll need to go through it and be able to make an appropriate decision. The same should apply to the issue of Batuk. They call it the British Army Training Unit in Kenya. I think the last that I know of, and I think Mr. Chairman, here we are lucky in that the Honorable Dido Raso was in that committee, and they know that they made some recommendations which were actually pending ratification by the House, but unfortunately, the House went into Sinedie recess. So it was a matter that will be coming up to the House, actually, before, for more ratifications. Yeah, thank you very much.
Our time is up, but there are members whom I can clear up with. Honorable Murugara, Posing, and Amisi. 1 minute each, please.
Thank you, Mr. Chairman, for my 1 minute. Congratulations, nominee to the office of the Honorable Attorney General. My question is this. Of late, we've actually seen the office of the Attorney General almost being mutilated, such that most of the agencies have been taken away from there, and maybe that is the reason why everybody believes it's losing color. Initially, even at independence, it had possibly all the departments, including prosecution, it had possibly the judiciary, and many others. We've seen the Executive Order number 1, which now vests the liaison between Parliament on legislation in the office of the Prime Cabinet Secretary. We are also told that soon you'll be losing the Asset Recovery Unit, because they believe it should not be anchored in office, should actually be with the anti-corruption. My question to you is, are there other areas you think we should be moving by way of legislation to bring back to your office, or even to add to your office, so that that color which is being lost is actually restored and your office goes back to where it used to be?
Thank you. Thank you, Chair. Thank you, Chair. Huh? It was okay. It was him and myself.
Okay.
Yeah. Thank you, Chair, for this great opportunity, and congratulations, Honorable Speaker, for being nominated to the office of the Attorney General. Chair, this is a very fundamental question, the nominee Speaker. It was asked by Honorable Bayer, but indifferently. Chair, you've been the Speaker. There's been this problem between both houses, that is National Assembly and Senate, particularly on summoning of ministers by committees. You find that this committee invites a minister for this question. The next minute you see the same minister is being invited in Senate, even on issues that might not even be necessarily be for counties. And that, Honorable Speaker, is a very, very fundamental question, because it affects services to the people of Kenya. And even the Speaker, it becomes even more necessary now that there's a proposal to amend the standing orders to bring ministers into the House. So the question is, will the ministers go to National Assembly, and after leaving National Assembly, they go to Senate? Will there be any work, Honorable Attorney General, that will go on in this country? What will be your able advice? Thank you, Chair.
Thank you, Chair. Congratulations, our nominee to that office of the Attorney General. Your predecessor's time, there was a frosty relationship between the executive and the judiciary. You remember the judges were not appointed. Our case, AG refused to continue our case at the International Court of Justice. The parliament dissolution was not obeyed, and many more. In a presidential system where we have the three arms of government, in your view, do you think this is a working system, or what is a lacuna, and how can you be able to cure it at that office? Because you have that advantage of having served in the three arms of government, the judiciary when you're magistrate, you've been the head of parliament, now you are going to advise the president. We have had this constant accusation and counter-accusation against the three arms of government. The executive does not obey the court orders. The judiciary is always annulling laws that are passed by parliament. Parliament is being accused of not funding the judiciary enough as a punishment. So it's always a squabble. How are you able to come in? Because you've had the advantage of serving both of you. We want to see change. In fact, you are the first politician to ever hold that office. Is Kenyans being hopeful in this, in your office, in your new tenure?
Yes, nominee.
So I see we've run short of time, Mr. Chairman. I'll do very quickly. But Mr. Chairman, allow me to inform the committee that I may be not the first person to serve in the three arms of government, knowing particularly the chairman himself began in the judiciary and has been in the cabinet. So that's maybe something that not many Kenyans are aware of. Yeah, I may not be the first one, but it's a good point. Let me go to the question by the Honorable Morugara, and it's a serious one. I don't think whether they really would be craving to have the judiciary being brought under the Attorney General. It suffices that the Attorney General is a member of the Judicial Service Commission, and from that position is able to advise on the issue of administration of justice. And also the fact that the Attorney General chairs the National Anti-Corruption Steering Campaign Steering Committee, which brings together the players in the justice sector, all of them. And without having to go to beginning to name all of them, that in itself places the office of the Attorney General in a very unique position to to run many of the functions that the AG's office is supposed to be. Law reform. Now, you've just talked about, the Honorable Murugara, Mr. Chairman, spoke about the asset recovery. Asset recovery is an agency that was created just the other day in 2009 when the Process of Crime and Anti-Money Laundering Act was enacted, and its operations placed under the Office of the Attorney General. Indeed, if you look at the Executive Order number 1, it is still there. It is still under the Office of the Attorney General. I don't think whether the Attorney General would want now to ask Parliament to bring more of this. But as you know, the responsibility to assign implementation of various laws is under the Constitution given to the President. And actually, some of it, like you may recall, when you enacted the Marriage Act the other day, you placed its administration under the Office of the Attorney General. Parliament actually did that, which is within its power to do. So I believe that what perhaps we need to do is to bring in policies that bring the Office of the Attorney General to its rightful place. And for me, my view, Mr. Chairman, for instance, is that the Attorney General's office, the state law office, should be like a premier law firm. It should be the place where even citizens would feel, inspired to visit to seek legal advice. I believe that kind of position has been eroded over the years, partly because of inadequate funding, and in fact, Mr. Chairman, the recent complaint from the Office of the Attorney General has been that they train state councils, and they end up losing most of them to, most interestingly, Mr. Chairman, to Parliament, to the judiciary, and to the ODPP. That is a matter that really the Attorney General should be able to address. It cannot be accepted that people will move from the state law office to go and work in the judiciary merely because maybe the remuneration is better or the working conditions there is better, or go to the ODPP. But honourable members, because I will be making proposals on budgetary allocation, you just need to walk to that place. I have not been there, Mr. Chairman, for a long time, but when I went there, I wondered where it was that I was going to. because it looks like it's a very small place. But it is a place where there's so much that touches on almost every arm of government. Yet it has not received the kind of requisite attention that is necessary to give it pride of place. I will be pleading with members, particularly the National Assembly, to see to it that that the other place is elevated, and even to retain qualified and experienced professional staff, and people feel inspired. You should, if you went to look at where they conduct marriages, it's like a small cubicle that nobody would even want to sit there for more than 20 minutes. You feel that you might find the cockroaches around. It's very pathetic. Mr. Chairman, there was a question by the Honorable Kosing, member for Pokot South, on the summoning of CSs. I think there is no conflict, because Article 125 talks of either House of Parliament or its committees can summon any person to appear before it, to give information or evidence. Now, remember the argument, Mr. Chairman, which I have been raising over the years, has been when it says either House of Parliament, where does the House of Parliament sit? It sits in plenary. It's because there was the issue of committees. So I think all we need to do is just organize ourselves a little bit well, so that everybody sticks to their mandate. I know the question being raised by the member for Pokot South is one that he has witnessed a lot of problems in dealing with. But I believe, Mr. Chairman, with you as a speaker, we will see a situation in which people stick to their lanes, so that what is for the National Assembly is the National Assembly, and what is for the Senate is for the Senate. But should there be concurrent, because there are those issues which are concurrent, the CSS should feel free to appear, before both houses. Mr. Chairman, finally, there was a question raised by the member for Saboti, the Honorable Caleb Amisi. It's like, of this system, is it working? Is the presidential system working? I think, given that we've had this constitution for the last 12 years or so, it is still work in progress. But we should not rush to change or try to fix this or the other until such time as we have fully implemented everything under the Constitution itself. But I think it is possible for everybody to obey the law. The Honorable Caleb Amisi, Mr. Chairman, was concerned about the executive particularly not respecting the other arms of government, the judiciary and parliament. But I want to say, well, sometimes it could be a matter of body chemistry. That maybe somebody felt that the certain decisions were not favorable. But of course, the rule of law demands that whatever has been pronounced by the judiciary should be obeyed until annulled. If it hasn't been annulled, the executive has no option but to obey it. So the same should be, especially, and I intend to really ensure this is followed, reports of parliamentary committees, because if we don't implement them, then it means that we are wasting taxpayers' money getting committees of the House, and the House coming to adopt those reports and make certain findings. I think it's only fair that there should be a mechanism. I know in the past there used to be something which was called Treasury Memorandum on implementation of past reports. I think we should go back to that, so that Parliament also is seen to be, so that whatever it is Parliament does is not seen to be acting in vain. if Parliament has recommended something, I think it's only fair. If somebody, the implementing agency thinks that there are difficulties, they should again appear before Parliament to explain those difficulties or why they are not able to implement what Parliament adopted. Thank you, Mr. Chairman.
Thank you, Honorable Muturi. Can I ask you one simple question? You and I have a history of having been magistrates. And when we were, you may recall, at 9 on the dot, you are on your bench. 2 on the dot, you are on your bench, dispensing justice to the public. Today, probably the only institution that keeps time in this country is Parliament. You go to court, your case is set for 9. By 11, there is no appearance of the judicial officer. Sometimes it gets to 1, you are told try at, you don't even come for the case, you try. Try at 3 or 4. And then eventually a clerk comes to announce to you that the judicial officer is unavailable. As a member of the Judicial Service Commission, what is going to be your engagement with the judiciary to ensure that we go back to the old working days and times? Because justice delayed is justice denied. And if you tell a litigant to be at the court at 9, they also budget for their time. That they'll be there at 9 and go to do something else. Then you just come and sit and yawn at the law court from morning to evening and go back home without your case being attended to.
Thank you, Mr. Chairman. I think, and you put it correctly, and I'm sure all these members are aware. I think it's only Parliament. It's only Parliament that is known to observe time, particularly in the plenary. Let me emphasize, particularly in the plenary. Mr. Chairman, and my position has always been, which is in the standing orders, that if for one reason or other a committee has not been able to start 30 minutes after the appointed time, you just disband, you adjourn. In the case of courts, I think it is something that we really must work as a policy, that in fact, being late, and during our time, as you've rightly pointed out, Mr. Chairman, if we were late by even 10 minutes, when you appear, the first thing you said was to apologize to the assembled litigants and counsel, because you always felt it was, you have done something so abominable that you want to apologize to the people in the court. Today, as you rightly said and have observed, that has disappeared. I think Judicial Service Commission should revisit those because these are just standards really. And we talk about backlog of cases. Some of it, the contributor is this non-appearance by judicial officers or lateness. I think there has not been sufficient monitoring of the conduct, in fact, I would call it the conduct of judicial officers when dispensing justice. And that, in a way, has contributed to both, with respect, sometimes you look at the quality of the output and you wonder whether the people making those decisions are really visiting the same institutions as you and I did. And it's a matter that I intend to, again, it's just to make suggestions because it's for the betterment of this country, it's for the good of the entire country. And I agree with you, Mr. Chairman, justice delayed is justice denied. We, judicial authority, again, judicial authority is derived from the people. And the judicial officers cannot imagine that they are supposed to lord over them. They derive whatever authority from the people. That's in Article 159. Thank you, Mr. Chairman.
Thank you, Honorable Justin Muturi, nominee for Attorney General. I'll now avail you 3 minutes to make your final appeal, if any, to this committee.
Mr. Chairman, first of all, I want to thank you and thank the members of this committee. I think this has been a very useful engagement, and if approved, honorable members, I promise and undertake to do my best to give the best available advice to government, both at the national level and at the county level in a collaborative way, as provided for in the Constitution, in the form of independent but interdependent. Thank you very much.
You are released to go. Honorable Muturi.
Thank you.
Thank you very much.
Thank you.